Councillor DeGenova's chair. There is quorum, and whenever you're ready to start.
Thanks so much. Good evening and welcome. This is a business license hearing to determine whether a 2022 business license should be issued to Russell Frinsky, the applicant, for a short-term rental accommodation at 2502-928 Richard Street, known as the premises. Before we begin, I have some opening remarks. This hearing is being convened by electronic means as authorized under Part 14 of the Procedure Bylaw. The City of Vancouver electronic meetings, as such, panel members may participate in person or by electronic means. If a panel member attending by electronic means loses connection during the voting process, staff are available to get you back online quickly while the voting process is suspended. The staff contact information has been circulated to you. Video of panel members speaking and vote results will be projected on the live stream when available. For panel members participating by electronic means, in accordance with Section 1413 of the Procedure Bylaw, please ensure your video is turned on and let the clerks know if you leave the meeting for purposes of confirming quorum. Thank you. We acknowledge that we are on the unceded homelands of the Musqueam, Squamish, and Tsleil-Waututh people. We thank them for having cared for this land and look forward to working with them in partnership as we continue to build this great city together. May we have the roll call, please? Clerks, can you hear me?
Yes. Good evening. Councillor DeGenova in the chair. Councillor Carr. Councillor Swanson.
Here.
You have a quorum, Chair DeGenova.
Thank you. We will start with opening remarks from Robert LeBlanc, Council for the City of Vancouver. Please go ahead, Robert.
Hearing counsel with the city, and I also act as city prosecutor. Just before I carry on, I'll note that the applicant is present in council chambers here, and he's accompanied by counsel. So I'll just pause and give them an opportunity to present themselves. Thank you. To the members of the panel, then, this hearing is a referral by the Chief License Inspector to this panel for determination of the renewal application for the business license issued to Mr. Frinsky for the provision of short-term rental accommodation at 2502 at 928 Richard Street in the City of Vancouver. The reason for the referrals of the Chief License Inspector is set out in the letter of January 27th, 2021 that was sent to the applicant. That's contained in the evidence material at tab 13. And I'm just going to read from a couple of paragraphs starting at page 55 of the materials. And I'll read from the top, being the first full paragraph. The city has determined that in consideration of the totality of information, including the information provided at the meeting, the inspection of your property, your high frequency of bookings, and information from community members, it does not support that 2502-928 Richard Street is your principal residence. As per the license bylaw 4450, section 25.1 sub 3, no person shall carry on business as a short-term rental accommodation operator unless the short-term rental accommodation being provided is the principal residence of that person. Just carrying on to the next paragraph. With regards to your 2021 business license that expired on December 31st, 2021, in view of the seriousness of the above-mentioned concerns and issues, if you apply for a 2022 license for the noted address, I will not support issuance until you can provide proof that you comply with the short-term rental bylaw regulations and the requirements of the license bylaw. So the letter of the Chief License Inspector specifically stipulates that the reason that we're here today is because the applicant has been unable to satisfy the principal residence requirement for the premises. It's worth noting that the definition of principal residence unit is contained within the license bylaw, and I'll read from that definition because it will be central to your consideration this evening. Principal residence unit means the usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs, including, without limitation, paying bills and receiving mail, and is generally the dwelling unit with the residence address used on documentation related to billing, identification, taxes, and insurance purposes, including, without limitation, income tax returns, medical services plan documentation, driver's licenses, personal identification, vehicle registration, and utility bill. And for the purposes of this bylaw, a person may only have one principal residence unit. The portion of that definition that I'm going to ask this panel to place its weight on is the first portion, being that principal residence unit means the usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs. The city today has one witness, and that's the city's Deputy Chief License Inspector, Mr. Miyagi. He will take you through the materials in the evidence book and explain the basis for the decision of the Chief License Inspector to refer the matter to this panel. What this panel can expect to hear is an indication that the decision of the Chief License Inspector required a weighing of the claim of principal residency by the applicant against a number of other factors. Those factors being a high booking volume in excess of 90% of the time over a 13-month period, an inspection of the property that showed no signs of principal residency, a statement made by the licensee applicant on the Airbnb listing indicating that he, quote unquote, lived in the suburbs, and complaints received from the community indicating that the operator owner did not reside at the property. The Chief License Inspector's conclusion that the evidence did not support principal residency is a reasonable one, and it logically flows that the license should not issue. Of course, the applicant has an opportunity this evening to convince this panel otherwise. But before embarking on the evidence, there are a couple of legal and procedural matters to note. The first is that this matter has been referred to this panel in accordance with Section 4, Sub 4 of the license bylaw that indicates, notwithstanding any other section of the license bylaw, the inspector may refer any application for a license to council, who may grant or refuse the application. Furthermore, Section 275 of the Vancouver Charter states the granting or refusal of a license to an applicant, therefore, and the revocation or suspension of a license which has been granted shall be deemed to be in the discretion of council, and the council may grant, refuse, revoke, or suspend the license without stating any reasons therefore, save in respect of a licensee who by reasonable efforts cannot be found. The council shall not revoke a license without giving the holder thereof an opportunity to be heard. Under that section, this panel has broad powers to revoke, suspend, or upheld or issue a business license. This is an administrative proceeding, and I'll remind the panel that the rules of natural justice do apply. The applicant is entitled to hear the evidence against them. The applicant may respond to that evidence. The applicant may ask questions of the witnesses who are presented and present their own witnesses, and the applicant may make submissions on their own behalf. If this panel sees fit to issue the license, deny the license application, or issue it with the stipulation of conditions on the license, you must give some reasons for doing so. in accordance with the decision of Regina and Vavilov of the Canadian Supreme Court. Those are my introductory remarks. As I noted, the city has the evidence of one witness. That's Mr. Koji Miyagi. Mr. Miyagi is the deputy deputy chief license inspector for the city and the assistant director of community standards. He's now just standing at the podium. I'll let him introduce himself and we can carry on.
Thank you, Mr. LeBlanc. Thank you, Chair, and the members of the panel. As mentioned, my name is Koji Miyagi. I am the Deputy Chief License Inspector for the City of Vancouver, and I'm also the Assistant Director of Community Standards, of which in that role I oversee the area called Proactive Enforcement. That area oversees the enforcement and the bylaw compliance work for the short-term rental activities, amongst other things. I also oversee the property use inspections area, and that area oversees a number of bylaws, including the on-site inspections that is conducted for the short-term rental activity, which one of the inspectors have done for this particular case file. I've been in this role for going on to into 4 years now, and I am familiar with this particular case file.
This particular case file relates to property at 2502 at 928 Richard Street. Is that right?
That is correct.
And where is that located in the city?
That is close to the Yaletown area, in the downtown area. It's also close to False Creek.
Can you just describe what the nature of the property is?
I believe it's a high rise or a higher rise downtown building. It looks relatively new. The suite itself, I believe, is 1 bedroom, and it's not huge, but it's a nice unit.
Now, in the course of your dealings with this file, I understand you requested from staff a timeline of events setting out a chronology of the enforcement activities relating to the premises at 2502 928 Richard Street.
That is correct, and you will find a summary of the timelines that I'll be referring to on page 3 of tab 2.
Thank you. I'll just let the panel get there. And Mr. Miyagi, maybe I'll ask that you turn there and just explain to the panel how this particular property became subject to enforcement activities by the short-term rental team.
Yes.
Chair DeGenova, Councillor Carr has a point of privilege.
Oh, thank you. I couldn't hear Councillor Carr. I'm not sure, but thank you for letting me know. Councillor Carr, your point of privilege. Maybe we can make sure your mic's on.
To have there.
No, I can hear you. Thank you.
No, there was some difficulty with the mic, but it is on. Thank you. I'm wondering because my package for this proceedings does not have the tabs marked. If you could note the page number that you are referring to rather than the tab.
I think Mr. Miyagi had referred to page 3 of tab 2. Page 3 is in the upper right-hand corner. All of the pages in the evidence package are numbered
Yes,
sequentially.
I see the numbers. I didn't realize it.
Okay.
I'm sorry, we should
Thank
have.
you. You have what you need, Councillor Carr? Thanks.
I believe so.
Okay. All right.
Thank you. Then, Mr. Miyagi, if you could pick up from page 3 and explain to the panel how this particular property became subject to enforcement by the short-term rental team.
Yes, through the chair, we have on record that Mr. Frinsky had applied for a 2020 short-term rental license, and it was issued in July of 2020. And then in 2020, also in July 2021, we've noted that Mr. Frinsky and Mr. Samarasekera, and pardon me if I mispronounced your name, had acquired this particular unit at 928 Richard Street, the one in question.
Sorry, is that July 21st, 2020?
That is correct. And I'm just stating certain facts that we have been able to uncover. Now, perhaps it's interesting to know that really it's in April 13th, 2021, we received a complaint regarding the Airbnb information that was online, and that complaint is received from the public, and we look at those, and it stated that that this particular host or individual that is running the Airbnb stated that they live in the suburbs.
I'm just going to ask, we have a complaint, short-term rental complaint on page 6 of the evidence package. That is dated April 13th. Is that the complaint, a copy of the complaint that was received by the city?
That is correct. And these go to my staff at Proactive Enforcement that then obviously take a look at following up on the actual legitimacy of the complaints.
And one of the portions of the complaint under point 4, the last paragraph, draws the city's attention to the fact that the listing clearly states we live in the suburbs but are available anytime.
That is correct.
And I take it that would have raised some red flags for the short-term rental team?
Yes, they frequently review these kind of pieces of information, and certainly we follow up with all complaints that are received, so that is part of that as well. And digging into this particular complaint, we're able to track down the actual listing of the Airbnb. And so perhaps if I can take you to page 12. This is the actual listing that we pulled, and it says here by hosted by Russ, and I presume that is the Mr. Frinsky. It says we live in the suburbs but are available anytime. Feel free to contact us, so on and so forth, as you can see there. And there are indications elsewhere that this suburbs is Langley.
The next notation on your timeline of events at page 3 indicates that an STR clerk then opened an enforcement file with respect to the property.
Yes. So this is a standard process where then we have acted on the complaint, verified pieces of information in there, and so we've decided it is based on the city interest to investigate this further. So hence, an investigation case file was created.
Now, I take it that the concern is what was confirmed on the Airbnb site, that the particular premises was not the principal residence of the operator / owner, because that person was living in the suburbs.
Yes, that triggered us to look at because of the notation of the suburbs, and so as part of the investigation, and we've noted some new information today. Should I mention that at this time, or
let's just carry on?
Okay, sure.
Now at October 22nd, 2021, there's a note that the STR clerk initiates an audit for the business license.
Yes.
Mr. Frinsky's business license. Can you tell the panel what an audit is and what that's supposed to reveal?
Yes, through the chair, we have two levels of audits. The initial one is this particular one that we started out where we start with a documentation audit, and that is done through emails and communications, and it's not an interview per se. It's communications through emails and whatnot to obtain various documentations to verify the legitimacy of the individual to see that they actually live there. And so that was started in October 22nd. In November and throughout to December, you also note that that we do tracking with Canada Post in terms of sending out the information, and just to make sure that the license holder does get the information that we're asking for. Um, and Mr. Frinsky did contact us, and we were able to obtain a number of those documents. Um,
I'm just following along the timeline of events. Those documents were supplied on November 8th, 2021.
that is correct.
I'm turning to page 16, which is the first page under tab 6, and I see a variety of documents here. I understand these to be the documents that were submitted by Mr. Frinsky in response to the audit request.
That is correct.
This first page, page 16, what is it that we're looking at here?
So this is an email from Mr. Frinsky to Ms. Holmes. She is our enforcement coordinator, and he's responding to the documentation that we've asked for. And if you look at A, B, C, and D, A is the primary documentation. Those are things like the government issue documentation, anything with photo ID, revenue tax. We cite certain examples in there, and he's provided us with a driver's license that you'll see in page 17. And B, there was a question about the strata not supporting the short-term rental activities in that building. We have verified that is not the case, that the strata does support it. And we do have documentation from Mr. Frinsky to say that that particular piece of compliance is achieved. We also asked for, and this is an important piece as well, the URL information and where we find the booking information. And we also asked for the last 12 months of bookings.
Why do you ask for that?
Well, through the chair, it helps us determine the degree of activity that is occurring on that particular location. It's also a very important piece of information for us to consider how the principal residency is being achieved or perhaps not achieved. And in this particular case, looking at the bookings, and we can get into that a little bit further, but it is very heavily booked, and to a point where I believe it's like 91% booked over the course of 13 months.
Maybe let's turn to those booking sheets. I think that they start on page 24. Is that right?
Yes, let me just get there. Yes, on page 24, we start with October, and sorry, a little bit dark in here.
The print is awfully small. I've made it out as starting with the first one on October 2020, and then the last one on page 30 being October 2021. Is that correct?
That is correct.
Okay, and it includes in that sequence all of the months in between.
That is correct. And looking at, just explaining to our panel, the solid lines indicate the dates of being booked, and then the blank calendar dates are interpreted as dates that are not booked. I did a quick count of, and the staff did that as well, of all the information that was provided pertaining to the bookings, and doing the math, we've been able to conclude that out of 396 days that are represented on these booking sheets, 359 of them were booked for short-term rental activity. And so therefore, doing the math, it comes out to approximately 9% of the time, or 37 days, if you will, spread out, that that Mr. Frinsky was actually able to stay, if he did stay, at this particular premise, because it wasn't booked.
Okay. If I understand that correctly, over the 13-month period from October 2020 to October 2021, there were only 37 days of vacancy.
That is correct.
What was the longest stretch of vacancy over that 13-month period?
Well, and looking at the dates through the chair, I've noted, I believe it was December of 2021, December 2020, I believe. No, there was 8 days anyways that, and it was in December here, and I just don't have my glasses on, but where there was 8 consecutive days that was available. That essentially wasn't booked.
Over a 13-month period, the longest that the owner of the property, Mr. Frinsky, could have stayed at his principal residence was 8 days. Is that what this calendar tells you?
That is correct. That's what this information provides us, and I'm just trying to identify which month that is. It was December of 2020, I believe, or 2021. I'm sorry.
I'm looking at page 25.
Yeah.
And I see the top graph has at least a full week clear there. That correlates to December 2020. Is that right?
Yes, that's correct.
Okay. So there was an 8-day stretch in December 2020. That was the longest stretch that the owner could have stayed at the property.
That is the longest stretch. The other pockets are either 1 day or maybe 2 or 3 days that we've identified. But we do see months that are solidly booked 100%.
And we can maybe just point some of those out.
Yeah, so those would be,
It looks like the summer months in 2021 were the busiest. Page 28.
yes, page 28, July 2021, there were 0 vacancies. The following day, we show maybe 2 days that were available. There was another one that was 0 days available as well. And through the chair, I guess the point that we would make, February of 2020, there was 0 days available. We take this information. This is provided by the property owner or the license holder, and so we would acknowledge its validity. That it is very heavily booked to a point where it helps us to determine whether there is actual principal residency at that particular location, as per defined by our bylaw.
As part of the documents that were supplied under the audit, you read from the first page, which was an email from Mr. Frinsky. That's at page 16. And under D, seems to be some information in terms of the operation of the unit.
Yes. Yes.
Point EI, Mr. Frinsky provides the information: while the unit is in use, I stay at my partner's house.
Yes.
Were you provided with an address from Mr. Frinsky as to what his partner's house was?
We were, I'm just going through the audit information because there is a secondary audit where we do the interviews. I'm not sure if we were actually provided with the address of where his partner resides and where he goes to. We were able to deduce through our work that it's in Langley, and he may have mentioned it's in Langley as well.
Well, maybe we can just go to some of those other records in the book. You noted that following the receipt of the documents, there was an interview. You just said. Can you just point out when that was on the timeline?
Yes.
On page 3, and explain what the interview is for.
Yes, and so through the chair, maybe we should just also note that as part of our investigation process, and as we progress in the information gathering, that's indicated by the fact that we feel noncompliance is the circumstance. And so one of the steps that we do take is the on-site inspection which is dated in December 23rd, that one of my PUI inspectors went on site and looked at the facility. And you'll see photos in the package that cite a very, we call the term sanitized unit, where it's sanitized in the sense that no personal belongings are there. With those pieces of information, then we go to the secondary audit, which is the verbal interview. So in terms of a compliance investigation process, this is, if you will, the last step where we find it very concerning that there may be a number of non-compliance matters. So through the interview process of the audit, we then try to have the license holder explain certain questions that we may have come across in our investigation. And of course, in this particular case, it was the high number of bookings that triggered this. It was the inspection that had very little personal belongings in there, and the statement in the ad that said that they live in the suburbs, and then the multiple complaints that we received from the public as well. That's all triggered into the audit, the interview audit.
Okay. And I see at tab 12, starting at page 44, we have a couple of documents, STR license audit meeting script and notes. That's starting at page 44 and going through to page 53. Can you just explain who produced these notes and when they did them?
Yes, through the chair, these are the actual audit, interview audit questions and the notations for the people that have interviewed Mr. Frinsky. The two individuals that did the interview was Ms. Claire Thompson. She is the manager of proactive enforcement, and so she manages this particular area. Mr. Nathaniel Chow is one of the compliance clerks, and his primary role is to take notations of the proceedings. And of course, Mr. Frinsky was present as well. I believe this was a telephone interview. And the questions that are asked are to determine, or to get us more information and provide the opportunity for the license holder to provide explanations on the questions that we have.
I'm going to draw your attention to a couple of
Yes.
couple of notes in the report. Page 47 at the very top, it appears as though the applicant was asked the question, where do you stay when your property is rented out? And he provides the answer, we would stay at my partner's house in Langley. And then I will ask you to turn to page 51, and these are the notes of Ms. Thompson. And this is towards the bottom of the page, again answering the same question. Her notes, where do you stay when your property is rented out? It's the very bottom. And the answer from Mr. Frinsky, I stay at my partner's house in suburbs in Langley. So both parties in the note, or in the meeting for the city, indicated that the question was asked and answered that when his place is booked, he stayed at his partner's place in Langley. Is that right?
Through the chair, yes, that is correct. He made no intent to deceive us in that concern, and indicated that he does stay in Langley during his bookings. For us, doing the math, that's 91% of the time. So therefore, it's difficult for us to understand how an individual could live in Langley for 90% of the time and then still declare the 928 Richard Street location as the primary residence. We just have some difficulty trying to comprehend that.
In the course of that, though, you weren't provided with an address as to what that particular property was, were you?
No, through the chair, we were going through this information, and we we were now provided with the address of the partner in Langley. We did do some investigation on that as well, and this afternoon we did find the actual address in Langley. Now, it is also stated, now that we look at it, in his ICBC record, and I believe that is on page 23.
These are the, again, the materials that were supplied in response to the audit request.
That is correct.
And page 23 is an ICBC record indicating an address history for Mr. Prinsky, correct?
That is correct. And through the chair, if you look at page 23, it dates back to 2002. And if you look at the second from the top address, it says 48752 202 Street, Langley. And it states here that he was there from 2018 and then left there 2020 in July, and then moved to the 928 Richard Street on July 24th, 2020. And then, but that was his address, is how it was indicated on here. And upon doing a bit more research and members of the panel and Mr. Frinsky has been provided with this information, we did a title search in the Langley property, and it shows that Mr. Frinsky and his partner are actually co-owners of that property on 4759 202 Langley. It's stated in the title search as joint tenants. And so once again, for the city, as we're investigating this, to try to understand how that's possible, where or what is the feasibility if an individual co-owns and lives in Langley, it's stated there in the title search, has stated in our interviews that he spends time in Langley when the property is being booked, the Vancouver property being booked. So that's 91% of the time. Now, and in the ICBC history, it says that he moved there in 2020 and obtained this property in Vancouver for the purpose of living there. And yet our records and his information tell us that he virtually did not stay there at all. And if anything, it's been booked so frequently, and it's sanitized to a point where it's completely empty, virtually empty of the personal belongings. And yes, there was explanations provided during the audit, but it just, the likelihood that this Vancouver property is his primary residence seem highly unlikely and highly unreasonable for us to conceive that that's his primary residence, where he does his daily living, daily activity, calls it a home, when in fact he states that he stays in Langley 91% of the time. So
I'm just going to pick up on that. You say he stays in Langley 91% of the time, when in fact that's not just what he says. He says he stays at his partner's house in Langley.
yes.
The address that you searched, though, as being his last residence on the ICBC record indicates he still owns that property.
Yes, through the chair. That's exactly what it states, is that they're joint tenants. So this piece of information that we did the title search on states he also lives there.
That's his mailing address.
That's his mailing address.
4759202 Langley Street.
And given the information that he provided to us through our audits and whatnot, the definition of the short-term rental, if you were to apply it to the Langley location, would actually apply, where the daily activities are done there, where you call home, primary residence. That would apply to this particular residence compared to the 928 Vancouver residents, the short-term rental residents. So based on these pieces of information, it was difficult for the chief license inspector and the staff when we were reviewing this case file to consider that this is in fact his primary residence. If anything, it looks like a very common situation that we come across often where it's used as a revenue property. It's purchased as a revenue property to rent short-term rentals and to use as short-term rental to generate revenue. Um, and so therefore that was the conclusion that we determined through our investigation.
Effectively, what seems to be the case is that the property was purchased in summer 2020 and used almost exclusively for short-term rentals, while in the meantime, the applicant misled the city by saying that he was going back to stay at his partner's place when in fact he was going back to stay at his own place in Langley.
That is correct. Through the chair, that is correct. That's the information that we've discovered. It may look like a fine detail, but it does connect a lot of the dots. And for him to say that it's his partner's place, well, in fact, it's his place as well.
You alluded to a couple of other things in the timeline, and maybe I'll just go back to that page, page 3. Maybe we'll just ask you to explain where we can find the entries under December 4th, 2021 and December 14th, 2021. It looks like 2 other complaints were received. Are those included in the materials?
Yes, through the chair, the complaint information is identified. We've noted page 6 was one of them. And then there are other complaints that are identified that we've noted.
I see one at page 31.
Yes.
That appears to be a complaint received December 4th, 2021.
Page 31 and page 33.
And there's 31 at point 4. The citizen complained of parties weekly at the Airbnb, and the owner lives in Langley. That's what was reported.
Yes.
And that appears to be borne out by the information provided by the applicant.
That is correct. That is correct. So these in total are 3 complaints that have also triggered but also supported our non-compliance suspicions for this particular case file.
And page 33, again, under point number 4, that repeats some of the earlier information from the Airbnb listing, noting that the listing shows or says that we live in the suburbs.
Yes, through the chair, that is correct. That point seems to resonate with a number of the complainants. And once again, we treat each one of these complaints seriously, and we look into those as well.
Okay, and then you noted the inspection, and it looks like on the timeline at page 3, the inspection was conducted December 23rd, 2021.
Yes, through the chair, there was an inspection done, and you will see the photos and the comments of the inspector on page 35. The POI inspector went on site, and Mr. Frinsky was there to greet the inspector and let him in. Just taking you through page 35. Of course, it's a very clean unit. 36, 37. The refrigerator is virtually empty. I know that it is cited that this was prior to Christmas and they had cleaned the unit out. I guess from our experience in looking at thousands of these, literally thousands of these, it is a very common pattern to see a very empty unit devoid of virtually any personal belongings, if at all. And if I can take you to to page 39, the closets are empty, virtually empty. We don't see any clothing. And the drawers on page 40 are mainly of beddings. Um, um, And I know that the explanations were provided about possible theft or that there were complaints about not enough closet space for the guests. Respecting that, I guess when you look at, as the letter stated in the chief license inspector's suspension, that in the totality of the information provided, it just seems highly unlikely that that someone put everything away for the purposes of the inspection and or for the Christmas holidays. And you know, if there were shoes or if there were photos or anything. And I guess, you know, the other point that I like to make based on that comment about theft and whatnot is that you know, it's your choice to run a short-term rental activity. And so if you feel those aren't appropriate, if those are concerns, you know, that is a choice that you make or a risk choice that you may have to consider when you're operating a short-term rental.
Now, in the residences that you've confirmed as principal residences under the license bylaw, what kinds of things have you found on inspections, and what kinds of things would you expect to find in a unit that is actually a principal residence unit?
Yes, through the chair, and these are just examples, mind you. And the inspector and the staff, and including myself, we all live in a residence, and we all know what kind of items that are commonly around a residence when you live there. And so we're looking at things like clothing. If you have a pet, we're looking at things like pet food. And once again, these are just indications. And when it's completely void of those kind of things, food, yes, I can assume perishables, but when there's no canned goods, when there's no dry goods, when there's no sauce, when there's no favorite food kind of things. But what you see is what you often find in a bed and breakfast or a hotel with a suite. That's the kind of thing that would trigger us to consider. So personal items, you know, toothbrush, toothpaste, yes, I suppose you can pack those away, but there would be spare items, there would be contact lens solutions, there would be extra glasses, anything that I think a reasonable individual, you and I, when we live somewhere, would have. And I guess using the reasonableness litmus test, we find these examples to be very, very unlikely that an individual packs everything up all the time. Now, in this particular case, it's 91% of the time. And so it is also leads us to think, yeah, well, perhaps you weren't living there. And the lack of materials there also support that suspicion.
Thank you. So it was in consideration of the high booking volume, the inspection of the property, the statement in the Airbnb listing with respect to living in the suburbs, and the community complaints that raised concern of the chief license inspector that this didn't satisfy the principal residency requirement under this short-term rental licensing scheme. Is that right?
Yes, through the chair, that is correct.
And that's why the matter has been referred to this panel for a decision on the matter.
That is correct.
All right, thank you. Those are my questions.
Thank you.
Thanks very much. I'm just going to ask now if any of the panel members, do you have any questions for Mr. Miyagi? I'm not seeing anyone on the queue. Does the applicant's counsel have any questions for the witness? So I understand, and I'm sorry if I mispronounced your name. The applicant's counsel is Jeffrey Hernays. Is that correct?
That's not correct.
I'm sorry. Please.
My name is Isaac Shea.
Oh, I'm so sorry. I had the wrong name in my. Thank you. Please proceed.
Okay. And so I'll just ask Mr. Miyagi the questions from here, and you. Okay, excellent. Okay.
When you're ready.
Thank you. Mr. Miyagi, through your testimony just now, we've heard you say a number of times that you can't imagine it being like this, and I'll quote one part of your testimony. You said, "It is difficult for us to conceive how someone can stay at another residence for 91% of the time at another address and for it to not be his or her principal residence." Do you recall saying that just now?
Thank you. Yes, through the chair, yes, I do recall saying that.
And in fact, so, and in one of the, what appears to be one of the primary reasons why the city based its decision not to support the short-term rental license is because of the number of bookings that you saw, right?
That's one of the reasons, yes.
Okay. Well, let me ask you then, because you just said earlier it's difficult for you to conceive. Well, what if it was a case of if someone frequently stayed over at his girlfriend's house?
It would be the same kind of thing where if you are doing a short-term rental activity, there is an expectation of permanent residency there.
And so are you saying that if someone got all of his mail at his house, he put it down on all of his tax returns, all of his information, his principal residence, but he spent most of his time at his girlfriend's house, then you would say that no, you live at your principal residence is your girlfriend's house?
We may lead to that conclusion. Those examples you cite are just examples of a larger whole. And so to achieve those specific pieces, in our opinion, may not define an individual's permanent residency.
Mr. Miyagi, I frankly could understand very little of what you just said here. I'm asking you, is in the city's definition, in their view, if someone stays over 90% at their girlfriend's house and they use their own residence as Airbnb, then the city has decided for, I don't know, for Revenue Canada, for the government, that this is no longer their principal residence?
We follow the definition of the bylaw.
Let's go to that definition of the bylaw then. So earlier we heard Mr. LeBlanc state verbatim the bylaw, and I take it you're well familiar with the bylaw, correct?
Yes, that's correct.
And so I'm just going to read that portion. It says that a principal resident unit means a usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs. And it goes on to state, including, without limitation, paying bills, receiving mail, is generally the dwelling unit with the residential address used on documentation related to billing, identification, taxation, and insurance purposes, including, without limitation, income tax returns, medical services plan documentation, driver's licenses, personal identification, vehicle registration, and utility bill. For the purposes of this bylaw, a person may only have one principal residence unit. And so, Mr. Miyagi, I'd like to go over this with you carefully because it seems like and correct me if I'm wrong, but it seems like the city is basing their non-support of Mr. Frinsky's application solely on the first phrase, where an individual lives, makes their home, and conducts their daily affairs. Is that correct?
That is the definition of the bylaw that we refer to, yes.
No. Well, I'm saying that there are 1, 2, 3, 4, 5. There's many additional lines that are added into that definition of a bylaw. Is that correct?
That's correct. We look at, and I think it's the first three statements where it talks about, sorry, I'm just trying to find it here, where one calls it a home, or what's the exact phrase there, and does their daily activity, that needs to be looked at. And that's what we look at as well. Those other examples that are cited are just that. They're examples, and I think it's also stated in the bylaw that those are just examples and not limited to.
Where does it say that, Mr. Miyagi, that these are just examples?
If you look at the letter that the chief license inspector sent, and it was also read, So, no person shall carry on a business with short-term rental accommodation, no, sorry, being a principal residence in a unit. Oh, where's that definition?
Mr. Braga, I'm going to take you back to the bylaw. I'm asking you right now just for the bylaw, not what the chief inspector wrote in his letter. In that bylaw we just read, there are numerous parts to it. Am I correct?
I think Mr. Miege should have a copy of the bylaw in front of him. If council has an extra
Yeah,
copy, you can furnish that.
can you cite the section that you're reading? I'm looking at. I'm
Sure. Perhaps I can turn your attention to page 57. We actually have it written out in our letter.
Yeah, that's what I was trying to find.
And take your time, Mr.
Yeah,
Miyake,
yeah. Thank you.
to answer.
okay.
There's
yes.
no time limit for you. I just wanted to
Oh, there it
interject.
is. Yes. Thank you. Yep. Sorry. Yeah. If
Oh,
you can
yeah.
repeat your question again.
Yeah, so my question is that we were just going over the bylaw right now, and you stated that those other sections I just read out are just examples.
Yes.
They're not part of the bylaw.
No. I don't think I said that. I said that those are examples of what helps us to identify where an individual lives and makes her home or conducts her daily affairs.
Okay, and does it say anywhere in this bylaw that those are just examples?
Well, including without limitation. It
Okay.
says right there.
And so those are illustrations, right? They're saying that these are part of what constitutes a principal residence.
Yes. Those are parts of it, but not the only thing.
And did Mr. Frinsky satisfy all of those other parts of the bylaw?
Some of those specific pieces he has. We consider that to be a minimum requirement of compliance to a bylaw. This bylaw is not difficult to come into compliance with.
Well, that's interesting because just now you said it's a minimum requirement. So are you saying that, for example, if someone doesn't use that residential address on their taxation, that's it?
No,
You're going to refuse your application?
we look at the totality of the information that's provided to us.
No. Right now you just said these are minimum requirements. Are you saying that every applicant has to have every single one of these pieces of documentation for their principal residence?
No, they don't. But they have to have, these are examples of ones that we look at.
Right. So these, if an applicant, would you agree with me that if an applicant has fulfilled all of these various other parts used on documentation related to billing, identification, taxation, insurance purposes without limitation, income tax returns, and so on and so forth, these are also indicators that that applicant uses that address. It is his principal residence.
It's part of the indicator, yes. We look at, once again, where an individual lives, makes her home, and conducts her daily affairs. So, yes, these other specific items are examples of what an individual may do, but there may be other examples that contradict the individual lives, makes their home, conducts their daily affairs.
Mr. Miyagi, I'm just asking you that these other indicators we just discussed, they can support. There are areas of support for an application. Is that correct?
They help support.
They are not just minimum requirements.
They help support.
So they are not just minimum requirements.
Well, they help support. So I don't know what more else I can say to clarify that.
I'm just using your own words. Earlier when I said Mr. Frinsky, did he comply with all those? You just said those are just minimum requirements. You seem to say those are not areas of support, but they're just a minimum baseline.
Yeah, you can interpret that my comments as, yes, if you provide just the documentation, we also look at other activities as well. So if you're asking in your questioning that if an individual provides just these documents, is that satisfactory for somebody meeting the requirements of the bylaw? And I would have to say not necessarily.
No, that's not what I asked at all. I just asked if those other parts of the bylaw can, if a person fulfills them, they can also be indicators of support.
Indicators of support, yes.
Thank you.
Is that all?
No.
Oh,
far from
oh,
it.
right, sorry.
Sorry.
There was a pause. My apologies. Go ahead.
Thank you. And Earl, just now we were also talking about the bookings, and you had pointed out, you'd gone over with Mr. LeBlanc the frequency of the bookings, right?
Hmm.
Yeah. And so you are, earlier, I can't quote you verbatim, but you said something along the lines that from, based on the bookings, Mr. Frinsky could not have lived at that address for, would not have lived at that address for 91% of the time. Is that correct?
I indicated that it's difficult for us to understand that an individual could claim that to be a permanent residence when they're not there for 91% of the time.
Yeah, and in fact, correct me if I'm wrong, but it seems like a lot of your testimony is based on what if you find hard to understand. You seem to be making a lot of assumptions today. In fact, earlier you mentioned that you think that someone, if they were to live in a residence, you would expect to see food items and whatnot, and that you could not understand how someone wouldn't have such food items. Is that correct?
No, that's not correct.
Mr. Miyagi, you don't know if, for a fact, Mr. Frinsky could not have lived at the Richard Street property for 91% of the time, right?
Sorry, can you repeat that again?
You don't know if, based on the Airbnb bookings, Mr. Frinsky could not have lived at the Richard Street property for 91% of the time.
We're just stating facts based on numbers that are provided by Mr. Finsky. So doing the math, the bookings show 91% of the nights were being booked.
Mr. Miyagi, that is not my question. My question is, do you know if Mr. Frinsky could not have stayed at the Richard Street property for 91% of the time?
I don't know for a fact, but with that said, that's why we do an investigation.
Right. So you're basing it on your investigation and the evidence you have available, right?
Based on the facts that we received.
Well, again, we're going to facts and then we're going to assumptions. And I think we have to differentiate that very clearly because you seem to be mixing up the two. Earlier just now, and correct me if I'm wrong, you just said it's a fact that he couldn't have stayed there 91% of the time, but that's not true, right?
That's not what no, I don't think that's what I said. I said the information that Mr. Frinsky provided does the math. You can do the math yourself, and it comes out to 91% of the time it was being booked. So an assumption is made on a reasonable basis, and that's part of my job, is to make assumptions based on reasonableness and the facts. The decision of this panel is what counts.
I didn't ask for your opinion on the decision of the panel, but so you would agree with me just now, you said that you are basing it on assumptions based on facts, correct?
Some assumptions are made, some assumptions or some information is provided by Mr. Frinsky himself.
Right. Assumptions, correct?
Well, if that's his assumptions, information is provided by Mr. Frinsky, and we use that information.
Well, let's go over to what you just mentioned about, or earlier with Mr. LeBlanc about the food items. And you said that it's hard for you to conceive that someone could be living at the unit and not have much, if any, food items, right?
Yes.
Yeah, so that's based on your assumption that most people have food items in the house if they live there, right?
Degree of reasonableness would state, and based on experience that I have doing these investigations, yes.
Okay, and so you see Mr. Frinsky here today. He's a young gentleman, right? And I don't mean to assume on your age, but Mr. Frinsky may have a dramatically different lifestyle from yours. Is that correct?
Perhaps. I'm not stating my lifestyle to his.
Right. So would you agree with me that when you assume what Mr. Frinsky's lifestyle is in terms of eating out or keeping food items in his fridge, it may be very different from yours?
Yeah, mine is not the point here. I base it on other investigations that I do, and I base it on the other short-term rental information that we obtain from other sources, and based on that reasonableness and the degree of the number of sites that we've looked at, yeah, to me, it looks like it's not lived in.
Right, to you. And you mentioned all the other investigations that you've done, but we don't have evidence of that here today, right? Do you have evidence for us to talk about these perhaps 95% of the houses you've looked at all have food items in there?
No, that would be unreasonable for us to have that here.
Right. So you're basing it on your own assumptions, correct?
No, I'm not. I'm basing it on my experience. So not my assumptions, but experience of what I've seen.
And Mr. Frinsky's experience and lifestyle may be, I'll use the word again, dramatically different from yours. Is that correct?
From mine personally, perhaps, but from other short-term renters that are in compliance, yeah, that's also different.
So you would agree with me that today you are trying to use your experience of how other short-term rental business license holder conduct their lives. You're trying to use it and applying it to Mr. Frinsky.
I use the definition in the bylaw, and through that definition of the bylaw, I use a professional interpretation based on my knowledge of my job.
Mr. Miyagi, we were not talking about the bylaw. You were just talking about your own experience in conducting these investigations.
No,
and suddenly you're jumping to the bylaw.
You were talking about my experience. I've always been talking about my bylaw.
No. Right now we're talking about you saying that it is very unusual in your experience conducting these investigations for persons not to have
My
food items.
professional experience.
I'm sorry, please let me finish. We were saying
Is there a
that-
question here?
Yes,
Please,
the question
thank you.
is that Mr. Miyagi was earlier saying that in his experience conducting these investigations, it's very unusual and unreasonable for persons not to have food items in their fridge. And I'm saying to you, by now you're saying it's a bylaw matter. And so which is it? Are you basing it on the bylaw that Mr. Frinsky doesn't have food items in his fridge, or is it based on your experience with previous investigations?
It's based on both. And I think your line of questioning, in my opinion, is irrelevant here because the facts show. And so perhaps I may have needed to proceed with saying in my professional opinion, but that's what this is.
Okay, let's go back to the bylaw. So we were just now talking about foodstuffs in someone's fridge. Can you point me to where in the bylaw it states anything about foodstuffs or keeping your fridge full for it to be a principal residence unit?
Yes, it says individual, usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs. I see that in there as having food stuff.
All right, right. In your experience, and in your, I won't say just your life, but perhaps in your other investigations, that's what would be part of where an individual lives, right?
Correct.
Yeah. So perhaps, would you consider that someone just eats out all the time, especially when they live out in the downtown area?
Perhaps.
Yeah, that's possible, right? That could be a reason why the fridge is bare.
Perhaps.
And I wanted to take you to earlier. You used the words. You said that Mr. Frinsky misled the city. I'd like to go over that. So, how do you feel? And before I go to that, I'd like to ask you: do you feel Mr. Frinsky has been forthright in all of his cooperation with the city regarding the audit?
I would say not all.
Could you elaborate?
Well, the fact that he didn't indicate that he actually owns the residence in Langley, where he stays, he didn't make a mention of that at all. So we had to go and find that out.
Did the city ask him for that information?
Sure, we did.
Can you point that out in the evidence book?
We asked him in terms of where he stays in Langley.
No, I'm asking you, can you point that out in an evidence book? When exactly or where did the city ask him that?
Where did we ask him where he lives in Langley?
When did you ask him that? Is it documented anywhere?
Through the audit, through the interview audit.
Let's go to the interview audit then.
Sure.
Okay, so it looks like it starts on about page 44, 45, 46. Can you point out anywhere in the interview audit notes where you asked Mr. Frinsky regarding his home ownership of the Langley property?
There we go. So, here, in review of the guidelines, we noted that very consistently high generally, where do you stay when your property is rented out? And then he states, we would stay at my partner's house in Langley. And then inspection of the property found very little personal belongings. This is a confirmed, sir. Yeah. So additionally, there's multiple complaints and yeah, so on and so forth. And I guess if he had nothing to hide, our hopes is that he would have explained this to us as well about his partner in Langley. He noted to us, or we do our research in terms of the ownership of the 928 property, and it shows that him and his partner own that property as well. And he stays at Langley for 91% of the time.
Mr. Miyagi, my question to you was, where in these notes, the audit notes, does it indicate that the city had asked Mr. Frinsky that his ownership of the Langley property?
We did not specifically ask that question. He could have voluntarily offered that information in the spirit of goodwill that we conduct these interviews. There's no reason why he would not wanted to share that if he felt if it was going to incriminate him, then maybe he withheld that.
So you're accusing, essentially now, you're using the words withhold, and earlier I had started off with misleading. And so based on Mr. Frinsky, you're saying the fact that he didn't volunteer this information, you consider that withholding information and misleading the city.
In my professional opinion, based on my investigations, yes.
Speaking of misleading, Mr. Miyagi, when you send inspectors to someone's property to conduct audits, what do you instruct your inspectors to tell those persons who reside at the property owners?
It's a bylaw inspection. It's part of the short-term rental bylaws for us to be able to inspect their property.
Do you ever tell your inspectors that they can mislead the property owner by saying that we're here to inspect your fire alarms when they're actually conducting a short-term rental inspection?
I don't personally instruct them of those specifics myself. I'm not aware of what my inspector had said to Mr. Frinsky. He does inspections many times.
Now, going to those complaints that the city received, and you had mentioned, and I believe Mr. LeBlanc and both yourself covered that part of the city's reasons for refusing to support Mr. Frinsky's license application is because of those complaints, right?
The complaints received, we take that into consideration, yes.
Did you interview those complainants?
I didn't personally know.
Did anyone from the city interview those complainants?
They may have, depending on the process, but the information that's received, we certainly look into them to check for validity.
Is it indicated anywhere in this evidence book of the city that either yourself or anyone from the city had interviewed them?
Not in this book, no. But we do investigate, and we've shown in this evidence book that we have followed up on those complaints to verify whether that is the case. So in one of the complaints or in a number of those complaints where it says the person lives in Langley, we looked into that to see if that was actually the case, and it actually did state that in the listing. So yes, we verified the validity of the complaint.
Mr. Miyagi, I'm going to suggest that you just answer my questions from now on. I believe me when I say we'll be here all night if you keep going beyond what I'm asking you of.
Sure.
And can you agree to that? Okay. So I'm going to ask that question again and see if you can answer it as I asked.
I don't
Mr.
think
Miyagi.
patronizing is particularly helpful to the process, so perhaps we can just try and keep it neutral.
Thank you.
I will if Mr.
I will take that under advisement. I am the chair of this. Thank you. I appreciate that comment, and I was going to say something if we continued down this road, but I will ask you to proceed with your questions. And if you're not satisfied with the answers, you can ask the question again. But let's not be patronizing to anyone this evening. Thank you. Isaac, do you have more questions?
Yes, I do.
Go ahead.
A question to you, Mr. Miyagi, and I'd like a straight answer.
Sure.
Is
I'll do my best.
thank you. Is it indicated anywhere in the evidence book that the city had interviewed those complainants?
No, it's not.
Thank you. And so you would agree with me that yourself and the city, you do not know the reason for why these complainants had made the complaint, if there were any ulterior reasons involved.
No, we would not.
And also the complaints mentioning things like excessive parting every other week, the city would not know the validity of that particular aspect of the complaint unless it investigated it, right?
Correct.
Earlier, Mr. Miyagi, you said something about a risk choice that is, and correct me if I'm wrong, that it's up to the applicant to accept the risk of potentially having their belongings stolen if they operated a short-term rental business. Is that correct?
Yes, I recall saying something like that.
But wouldn't you say that it is a valid reason for not keeping your personal belongings in a short-term rental unit to not have your belongings stolen?
Some belongings, perhaps.
Okay, and what belongings would those be?
Perhaps whatever you feel is valuable.
Are there more questions?
Yes, a few more. Thank you. Mr. Miyagi, has the city published any guidance to to the public regarding what the city expects in terms of how, going back to that bylaw, of what exactly constitutes a usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs?
Yes, it's on the website.
And what does that say, if you can recall?
There are videos that show where you live, how you live. It's animated, so it should be easy to understand that this is your primary residence. It also explains the bylaw. When an individual applies, they're asked to read the bylaw. And so those are all pieces of public information that when an applicant applies, that they go into this with their best understanding.
Do you have a copy of this video for the members of the council to see today?
No, I don't. I didn't know you were going to ask that, so I didn't prepare
I,
it.
I'm sorry. I just wanted to say I haven't seen any members of. We did have an opportunity to ask questions, and we will again later. But I have not seen any counselors. Please call a point of privilege, Counselor Swanson or Counselor Carr, if I missed you requesting this as panel members. But I don't see requests from panel members for that. Isaac, you can um, just to note that. So if that's your request, that's different. But um, we would have to take a recess probably then.
Well, without putting aside the video for today, putting aside that video for today, is there any other guidance for the public as to what exactly constitutes a principal residence unit aside from this bylaw?
Well, once again, and I can't cite exactly what's all the words in the bylaw or in the website, but there is pretty good information there that that show what's expected when you're applying for a short-term rental business license.
Is it contained anywhere in this book of evidence?
No, well, the bylaw itself is fairly explanatory, in my professional opinion, and that's included in the evidence package.
So in that bylaw that we've gone over in fair depth today, it doesn't say anything about how often a person has to live in their principal residence unit in order for the city to consider it their principal residence. Is that correct?
That is correct. The bylaw is purposely silent on the number of nights because for the purposes of achieving the policy objectives and preserving the rental housing stock in Vancouver, which is the primary objective. The indications of specific number of nights is purposely omitted.
You don't think it might be too ambiguous for a citizen who wants to comply with the bylaw to the letter, but just sees here where an individual lives and makes their home and conducts their daily affairs?
In my professional opinion, and with all the number of other compliant individuals that hold the short-term rental license, no, I do not.
And earlier with Mr. LeBlanc, you had mentioned this Langley address. You had mentioned that the city later discovered that Mr. Frinsky owned it with his partner, Mr. Samaruska. Is that correct?
Yes, the title search, is that what you're referring to?
Yes, that's right.
Yeah.
And earlier you had said that that Langley address is his mailing address. Do you recall saying that?
I don't know if I recall that specifically, but it states an address.
But you don't know if it's his mailing address, right?
Well, it says joint tenants, so I would assume that's a mailing address.
Do you know if Mr. Frinsky receives any mail whatsoever at that address?
I do not know that, but I'm just going from the information that's provided in the title search document.
Right. So you don't know if Mr. Frinsky lists that address in any part of his personal or professional life?
No, I do not.
I'm going to go over, I'd like to go over very quickly with you, Mr. Miyagi, this timeline from June 3rd of 2020 up till January of 2022. Because earlier we had been discussing how you said that Mr. Frinsky, you felt that he'd misled the city. And we talked a bit about how you felt he should have volunteered the information during the audit call. Is there any other reason for why you base your statement that you felt Mr. Frinsky misled the city?
You would have to be more specific, I'm sorry, about what you felt when I said that he misled.
Or perhaps I can rephrase this. So earlier I'd asked you, do you feel Mr. Frinsky has been candid and honest throughout this audit process?
I believe he provided information. In my professional opinion, I believe he could have provided more information.
One more point I'd like to cover. So during that, I'll direct your attention back to page 44, which is the license audit meeting script and notes. And correct me if I'm wrong, but earlier you had said that this interview audit was another avenue for the city to investigate information from the applicant. Is that correct?
That is correct.
Okay. So I'd like to take your attention to starting page 46 and going on to page 47. You would say that this is an accurate depiction of that audit interview, correct?
These are notes that are taken, so as accurate as they're able to take the notes, you'll have to understand that this is not a court of law, so it's not scripted verbatim. These are notes that are taken furiously through a discussion process by a clerk and also by the manager who is performing that task of asking questions.
Okay. Well, I'd like to take your attention to page 47. Here, if you look at the top, there's these lines where it says, the inspection of your property found very little personal belongings. Then second line, there's additionally, there have been multiple complaints. And the third line says your Airbnb profile says we live in the suburbs, are available at any time. So these, it appears that the city is making these allegations, or the interviewer was making these allegations during this interview, right?
Well, they're statements of facts, not allegations.
So these weren't fact-finding questions from Mr. Frinsky, right?
These were clarification questions based on the facts that we've discovered.
Well, it says on the next line, RF, which appears to be abbreviated for Russell Frinsky. He says, can I respond to all of those? So would you agree with me that it appears Mr. Frinsky, these are not so much questions than they were just allegations during that audit interview?
They're questions. They're stating a fact that the investigation or the inspector's visit showed very little personal belongings.
I'm having trouble finding where the questions are. You're saying that this interview audit was a fact-finding interview, but I don't see any questions. Can you point me to any?
Well, once again, these are scribed, and the questions. So there's two. We provide two drafts of these audit notes. So once again, they're not scribes from a court where it's taken verbatim. So you have Ms. Thompson's version and you have Mr. Chow's version. And that's, we provide this information to capture as accurate as possible what was being discussed. And so, yes, if you look at the front of the interview, there's a whole series of questions that flow. And so these are conversations that are captured in the process. And in Ms. Thompson, in what you cited in page 44, is a version that so notes taken by Mr. Chow. Okay, so that's what he heard. Now, once again, they're not taken verbatim, so whether it's written as a question or whether it's written as a statement, the you would look at the flow of the information going back and forth to determine in what manner it was asked. These aren't defined forms with specific, so it may have been asked as a question for all the purposes of my use for the investigation package. So if we look at Ms. Thompson's interpretation of that particular question, it it may not necessarily be worded as a question, but these are notes that are taken to make sure that we haven't misunderstood anything. So if you're asking, are these questions and pointing out a question, I can't reasonably answer that because I was not present during the interview process. But the purpose of this is to obtain the information and capture it to the best of our ability.
So you are saying today, Mr. Miyagi, that these audit interviews are meant to, they're supposed to be fact-finding investigations from the applicant.
Yeah, yes, they're fact finding, they're clarifications of questions that we have.
So questions are supposed to be asked in these audit interviews.
Yes, they are.
I'll take you to page 47. I'd say about the fourth line from the bottom. And there appears Claire Thompson, CT, said, "My recommendation for the chief license inspector is to not support this license for 2022, primarily based on PR, primary residence." Am I reading that correctly?
Yes.
So it looks like during this audit interview, shortly after the Ms. Thompson had made up her mind.
Well,
I don't think he can speculate as to, just to the chair, as to what the interviewer was.
I was
was
waiting
asking.
for a question there. I was on the line. So do you have a question, Isaac? And can I just ask, for the purposes of when I'm going to call a short recess, can you share with us how many questions
Oh
you
yeah,
have
I'm actually almost
left?
done. That's actually my last
Okay.
line of inquiry.
Okay.
Yeah.
So would you like to ask your question again?
Yeah, my question is that based on this line here, it appears that Ms. Claire Thompson had already made up her mind, right?
well, as Mr. LeBlanc states, I can't speculate as to what Ms. Thompson may have meant by that.
But is it normal for an interviewer at these audit interviews to tell someone that they've made their decision, that they're not supporting the applicant?
It may be depending on the information that's shared.
Okay. So you're saying that sometimes there could be no further consideration after this interview audit. They have made up their minds during the interview.
Well, it's their recommendation. The decision is made by the chief license inspector or in her absence by me. And so therefore it's a recommendation. It's not a decision.
Thank you. Nothing further.
Okay.
Okay, thanks. I'm going to suggest that we take a 5-minute break. Council, let's take a 6-minute break and come back at 7:40. Is that okay with everyone? I'm seeing some hopefully nods. Okay, see everyone then. Thanks.
Like what you do.
And I know you sent me
verify.
Mailing
It being a
address?
mailing ad-
Oh, this says
just say
mailing
what
address.
is
Chair DeGenova, you have a quorum.
Thank you very much. We will now move on to opening remarks from the applicant, or in this case, the applicant's counsel. Please
If
go
I
ahead.
could just interject, Madam Chair, questions were put to Mr. Miyagi on cross-examination with respect to the mailing address on the land title document that he saw with respect to the property at 4759 202 Street in Langley. I think it warrants some clarification, so I'm just going to ask for leave to ask Mr. Miyagi some further questions about that document.
Of course, please go ahead.
Thank you. Mr. Miyagi, if you could just...
I may, I'd just like to voice my objection to that. Mr. Long and in his hour before this had it.
Maybe I'll just respond to that. I wasn't going to put the document before the panel. I was going to ask Mr. Miyagi questions about the document that he observed before coming to the hearing today. That said, if this panel feels that the land title document with respect to the property that Mr. Frinsky co-owns in Langley that he says that he stays at while he rents out his apartment on Richard Street is relevant, and this panel would like to see that document, I think that it's properly admissible before this panel in that it may weigh on your decision in terms of the amount of weight you put on what Mr. Frinsky has to say. And it's open to this panel to make a motion to take that document into evidence. So maybe I'll just leave that with the panel. If there is no motion, I'll just simply proceed to ask Mr. Miyagi questions about it.
I'd like to just clarify with the clerk that is something council could make a motion to see later if they felt that they needed to. Is that correct?
Yeah, point of procedure?
Yes. Thank you, Councillor Carr. Please go ahead.
Yes.
I was waiting for I'm going to wait for the clerk to answer my question first, though, please. I'm just waiting to make sure that we can, in fact, have a motion later on, if warranted, to consider bringing that document into evidence, or must that be made now? That's a question to the clerk. I'll ask the clerk to clarify.
If I could just maybe relay my experience in these hearings before the panel.
I'm just going to wait for the clerk to clarify whether or not that's acceptable in our
Chair-
proceedings, and then I'll allow you to speak about that, Robert.
Thank you.
Yes,
Yeah,
go ahead.
Chair DeGenova, I don't believe a motion would be necessary.
Okay, thank you very much. So a motion, I understand, is not necessary. If you'd like to bring that into evidence, so you can at any time.
I may just for the record. Oh, I'm sorry.
I'm sorry, you'll have to speak into the microphone or else I cannot.
Sorry. I would like to put for the record that it is procedurally unfair for this council or for any tribunal for that matter to consider evidence that the applicant has not had a chance to examine, and receiving evidence 1 hour before a hearing is not giving procedural fairness to an applicant.
So I would, council, I'm going to suggest that we may need to take a very short recess, and I'm going to ask the clerk to call me, because I'm going to need to make sure that procedurally we are following our procedure, and if that is a part of the procedure, that I take that into consideration. So could I ask that the clerk please call me, and then we can decide if we need to contact legal as to whether or not that's admissible at this point. Is that possible for the clerk to contact me? If so, I'm going to suggest we take a 5-minute recess, a 4-minute recess. Let's try and come back for 7:50. Thanks.
I mean, I think it would. Okay. Um,
Yeah.
Hi, good afternoon. Chair DeGenova. Are we ready to reconvene?
If we have quorum, clerk, I'm ready when I have confirmation that we have quorum. I think we'd probably need, I know Councillor Carr's in chambers.
Yes, she is in chamber, and I believe we've got we have both yourself and Councillor Swanson is there too, so we can reconvene.
Councillor Swanson, you're on the line. I see you online.
Yep, I'm here.
Okay. Thanks very much, Councillor Swanson. To proceed, what I'm going to say is any councillor can make a motion if they want. I don't see any councillor making a motion. A councillor can make a motion later if they want, but that hasn't happened right now. So we'll move along. And Robert, please go ahead with any other questions that you have
Thank
at
you.
this point.
Thank you, Mr. Miyagi. I'd indicated earlier that I was seeking to ask questions to you to clarify some of your answers to the applicant's counsel. Applicant's counsel referred to you in his cross-examination to the title certificate that you'd viewed earlier today with the question, you don't know whether that is the Langley address is Mr. Frinsky's mailing address. Is that right?
That is correct.
You've had a chance subsequent to that question to actually take a closer look at the title document for the property at 4759202 Street in Langley with respect to a mailing address, and you can share with the panel what's referenced on that title document. Is that right?
Yes, through the chair, I could indicate that it says registered owner / mailing address, and then it states Mr. Frinsky's name as well as his partner, and it states the Langley address 4759202 Street. So it clearly states it's the mailing address.
Thank you. That's my only question.
Oh, okay. So we will now move on to opening remarks from the applicant, or the applicant's counsel in this case. Please go ahead.
Thank you. Mr. and Madam Councilors, the applicant, Mr. Russell Frinsky, he has always strove to comply with the conditions of the short-term rental business license issued by the city. Before he even obtained the license, he looked up the requirements. He looked up what he had to do before and after he obtained a license. He saw that there were a number of conditions, that he had to keep a fire extinguisher on the premises, that he had to make sure that it complied with all city bylaws, with the strata council bylaws. Mr. Frinsky, you'll hear from him today later, and he will testify the efforts he has made to comply with the conditions. One of those conditions is at issue today, and that is that the short-term rental business can only be conducted in Mr. Frinsky's principal residence. This is what is at issue today, and this is what has really tripped up Mr. Frinsky. He thought he was in compliance. He tried to be in compliance, but the city has decided that he is not. So Mr. Frinsky, at this Richard Street address, he receives all of his mail, all of his bills there. When he obtained the short-term rental business license, he made that his principal address. He changed all of his information with ICBC, with Revenue Canada, for all of his identification, for all of his employment information, for his W-2s, everything. He changed it to that Richard Street address because he made it his home. You'll hear from Mr. Frinsky today that when he was not renting out that unit, he lived at the Richard Street property. He rented it out a lot in that time period of 2020 to approximately the end of 2021. But as we all know, there was a pandemic going on, and you'll hear from Mr. Frinsky why, because of the pandemic, he stayed far less at that Richard Street property than he normally would have. And one of those overarching reasons is because it is a small unit. It is 550 square feet. It is a very small apartment unit in downtown, and Mr. Frinsky often worked from home. And so for him to live and work there, it was not ideal. The city's chief license inspector disagrees and claims that Richard Street property at 928 is not Mr. Frinsky's principal residence based on 4 grounds: the high frequency of bookings for the unit, the lack of personal belongings in the unit, a single statement for the Airbnb advertisement for the unit, and complaints from residents in the building. You'll hear from Mr. Frinsky later or very shortly, and we are confident that you will find he has honest reasons for each of those 4 reasons on which the city bases its decision. You will hear from Mr. Frinsky that ever since the city began auditing him, he has tried his best to be candid and as forthright as possible. He wants to keep his short-term rental business, and he wants to be in compliance. You will also hear from Mr. Frinsky that throughout his experience in dealing with the city of Vancouver, the city, in his view, has already made up its mind from day one. The city did not seem interested in hearing at all his reasons for his unique lifestyle, for the way he conducts his work, his life, and they frankly did not give him a chance to explain his side of the story, notwithstanding the audit interview. We ask that you keep an open mind and, for really the first time, give Mr. Frinsky a fair chance to explain his side of the story. Thank you. At this time, I'll call Mr. Frinsky to the stand, please.
He can sit here.
Yeah.
Use his microphone.
Oh, okay, it's there. Yes, sir. All right, Mr. Frinsky, could you please state your full name for the record?
Russell Allen Frinsky.
And are you the applicant here today for the short-term rental business license?
Yes, I am.
And could you introduce yourself briefly, starting with what is your occupation?
I am in steel sales.
And what exactly does that constitute?
So I sell steel tubing to customers all over the Lower Mainland. And I go visit them at their place of work as well as work from my home.
And generally, where do you live?
Vancouver, BC.
Okay. And how long have you lived in Vancouver for?
Since August 1st, 2020.
Where did you live prior to that?
I lived in Langley.
What is the residential address of where you live in Vancouver?
Unit 2502, 928 Richard Street, Vancouver, BC.
And do you own this property?
I do, yes.
Do you own it solely?
No, me and my partner co-own the property.
And who is your partner?
Danuka Samara Sekera.
Who lives at this property aside from yourself?
Just me.
Does I'm sorry, I'm going to refer to him as Danuka. Sometimes I mispronounce it still. Does Danuka live there?
No, he does not.
Why not?
So he works in the suburbs in Surrey, and so he lives at our Langley property.
So when you say the Langley property, is that a house that Danuka lives in right now?
Yes, correct.
Okay. Did you previously live there?
I did, yes.
Okay. But, and just now you said you started living in Vancouver in August of 2020, right?
That's correct.
Okay. So why this change?
So we used to live downtown together, and he got a job in the suburbs, so we both moved out to the suburbs. Once I realized I didn't like it as much as we both thought we would, We thought we would buy a property downtown for me to live in.
And is that the reason for why you purchased that Ridgeway Street property?
Yes, that's correct.
When did you purchase it?
The purchase was in July 2020, and possession was August 1st, 2020.
And after you bought it, did you start living in it?
I did, yes.
And you eventually applied to the City of Vancouver for a short-term rental license, right?
That's correct.
Okay. And when did you obtain, did you obtain this license?
I obtained it, yes,
And when was that?
July 20th, 2020.
And did you start renting out the property?
Not right away. My first booking was in October of 2020.
What happened at the property between July or August and October of 2020?
I was living there full time.
So when you started renting it out in October of 2020, how often did you rent it out for?
So it varied from month to month, sometimes twice, sometimes 4 times, just depending on when I was there or when I was not there.
When you say twice or 4 times, how many days usually a month would you rent it out?
Some of the bookings were a week, some of them were 2 days, just depending.
Okay. And so, for example, in October and November of 2020, how often did you rent out the Richards Street property? Approximately.
Approximately about, I would say 2.5 weeks, 3 weeks.
Okay. And so for the time, the 1 week or so that you weren't renting out the property, did you use it?
Yes, I was there.
When you applied to the city for a short-term rental business license, did you intend to rent out that Richard Street property for, like you said, about 3 weeks a month?
I wasn't sure at the time how long I would be renting it for, but because of the pandemic, I was renting it more than I had expected to.
And why were you renting it more than you expected to?
So, like it's been stated already, the unit is 550 square feet, and I was at home working. Because of the pandemic, I was not able to go visit my clients, and therefore I was basically stuck in the condo. So, because of that, I was renting it more often than I planned on.
And did you think it was okay for you to rent it more often?
Yes, I did. The reasoning is because the bylaw doesn't state exactly how many days that you need to be staying there. Had I known there was some sort of minimum, I would have definitely obliged or applied that.
So, are you saying that before you started renting it out more, that you had looked at the city bylaw?
Correct. I looked at all the city bylaws before renting it out.
Are you still renting out the property today?
Not today, no. I was given a letter to stop renting, so I have.
And what did you do with the property after you stopped renting it out?
So I've been staying there as much as possible because the pandemic is not over, obviously, but the restrictions have eased and I am able to go and enjoy the property more.
So you rented out that Richard Street property, correct me if I'm wrong, from approximately September, October of 2020 to when?
To December 2021.
And during this time when you were renting it out, did you ever receive any complaints whatsoever from your neighbors at that building?
No, I did not.
And just to clarify, the Richard Street property, what sort of house or property is it?
It's a condo unit.
Okay. A condo unit meaning like a high
Oh,
rise.
sorry, a high rise, yes.
Did any of your renters mention that they had received complaints from the neighbors?
No, they had not.
Did you ever have any issues from your neighbors during that time you rented out the Richard Street property?
No.
So, um, speaking of these complaints, Mr. Frinsky, you were here earlier today and you heard Mr. Miyagi's testimony regarding the complaints, right?
Yes, correct.
When did you first hear about those complaints that the city allegedly received?
The first time I heard about the complaints was during my meeting with Ms. Thompson and STR clerk Nathaniel Chow.
Okay. And is that the meeting that is documented in starting page 44 of the city's evidence book?
Yes, that's correct.
And so prior to this meeting, you're saying you had no knowledge of any complaints.
That's correct.
And during this meeting with Ms. Thompson and Mr. Chow, did you learn anything about the nature of the complaints?
So I did ask for clarification because I was quite surprised by the complaints. Ms. Thompson told me that she wasn't able to give me a lot of information. However, she could tell me what the complaints specifically were. So there was a noise complaint and also 2 complaints saying that I do not live in the residence.
What was your response to Ms. Thompson when you heard that?
I was shocked, and I didn't know what really to say to her because there was nothing, she couldn't give me any more information. I have since, though, found out more information about the complaints doing my own research.
What did you find out?
So I was on the Strata Council for my building for the last year, and 2 of the council members on the council and I didn't get along very well. We had a lot of disagreements about how things should be run, including firing our building manager and other things like that, of that nature. They decided they were going to call a hearing themselves so that they could try and stop my short-term residence license, rental license, sorry. And so the hearing happened. At the hearing, both of the members of the council said that they had complained to the city. So that's how I know who the complaints are from. But they said they did so in retaliation to the meeting prior where I spoke to them and they didn't like how I spoke to them.
Okay, let me take you through this, Mr. Frinsky. So you said there was an earlier meeting between yourself and those 2 persons you later found out were the complainants. Is that correct?
Yes, that's correct.
First of all, who are those 2 persons you found out at that meeting?
Is John Steinfield and Costa Pangiotacos.
And when was this initial meeting, strata meeting, you said, with Mr. Steinfeld and Mr. Costa Pangiotacos?
The meeting where they said I didn't speak to them properly was in the November strata meeting, end of November 2021.
And when was the subsequent meeting when you spoke to Mr. Steinfeld and Mr. Costa Pangiotacos?
So they called a hearing for the January meeting, January 2022 meeting.
Can you describe for us a bit more what happened at this meeting?
Sure. So both of the gentlemen that was brought up today asked me questions about where I live and just like what's happening today. I supplied all the documentation of what they asked for. Just for record, they both did approve my short-term rental license or send approval that the Strata approves of my short-term rental license in April when I applied for it, when I applied for it originally. Then at the meeting, I gave all my documentation. We talked about, they asked me questions, which I answered, and the outcome of the meeting was a 4-2 vote in favor of my side of the story. The two no votes were both Costa Pangiatakos and John Steinfield. In fact, I have a letter from the president of the strata at the time stating that all of this did occur. If I can have a copy for anybody if they would like it.
Thank you. And earlier you mentioned that they had said this was retaliation. Can you elaborate a bit more on that?
Yeah, so the previous month, we had argued because we are looking to fire the building manager, and things got a little heated, and I explained to the Costa Pangiatakos, as he's the treasurer, that he was not a good treasurer for the building. He doesn't do any, he doesn't bring anything to the table for the Strata Council. To which, of course, then things got more heated, and it led to him now accusing me of not living in the suite.
But so this alleged retaliation, what made you think it was retaliation?
They both said that it was retaliation. That's why I know that it was.
They said this directly to you?
Correct.
And when was this?
This was at the January hearing, January 2022 hearing.
So, Mr. Frinsky, during this period from September, October of 2020 to January of 2022, where was your home?
My home was at 928 Richard Street.
And why do you consider it your home?
Because I lived there. I go around town about there. I use the restaurants in the neighborhood. I use the gym in the apartment building, the pool. My friends live there, so I hang out there quite often with my friends. All my bills come there as per the definition, so I followed that as much as I could.
Okay. You understand, though, that the reason we're here is because the city believes that your residence, your principal residence, is not the 928 Richards property. And do you agree with that?
I understand that's why we're here. Do I agree with it? No, I don't.
You have a vehicle, Mr. Frinsky.
I do, yes.
And what is the address you provided for the vehicle registration?
Unit 2502928 Richard Street.
Did you file your 2020 and 2021 tax returns?
I did, yes.
What was the address you listed in those two tax returns?
Unit 2502928 Richard Street.
You mentioned you're employed as a steel purchaser, right?
Steel salesperson, yes.
Sorry, salesperson. What address do you currently list for your employment, for your office?
Unit 2502928 Richard Street.
And this is your home address you provided to your office?
Correct, yes.
During the period of September 2020 to January 2022, where did you conduct most of your personal and business affairs?
Everything was done through 2502928 Richard Street.
What about, Mr. Frinsky, the city's allegation that you've spent most of your time at the Langley property with your partner?
I will agree to that. I will say that it was not my intention. It was due to the pandemic. And like I said before, having to work out of a small 550 square foot apartment, there's way more space at my partner's house for me to do my work. Also, living alone, even though I know that's my choice, it's hard during a pandemic when you can't see other people, you can't interact like you normally would. So me spending time at my partner's place helped me get through the pandemic that way as well.
Mr. Frinsky, do you have a copy of the city's book of evidence in front of you?
I do, yeah.
Okay. I would ask at this time that you turn to page 13. Do you recognize this letter?
Yes.
Have you seen it before?
Yes, I have.
And when was that?
It was October 22nd.
Okay. And what is this letter?
It's an audit notification letter.
And you have previously reviewed this?
Yes.
What was your understanding of the letter when you previously received it?
I understood that it seemed to be random, as at the time I didn't know about the complaints, which I guess is what has caused this. But um, I assumed it was just a random audit of a short-term rental.
Okay. And what did you do in response?
I complied with and gave all the documentation required within the time required, and I sent it off November 8th, I believe.
Yeah, and so I'll turn your attention to page 16. Do you recognize what's on
Yes,
page
I
16?
wrote that email
Okay. And who did you write this email to?
to Alexander Holmes.
Okay. And why did you write this email?
This is my response to the letter that you just asked me about on page 13.
And did you attach anything to this letter?
Yes, all the documents that I attached are behind this, so page 17 through 30.
And is this all of the documentation you attached, was it all of the documents the city requested in their letter on page 13?
Yes.
After you provided this email to the city, did you contact the city afterwards to discuss any of this?
I tried to. I didn't get a hold of anybody. They said they were working on it.
Did anyone from the city contact you after you sent that email to them?
So the next contact I had with the city was a letter being pasted to the building, which was seen by my building manager to let me know of an inspection.
When was that?
That was, sorry, I believe November 16th. November 16th,
Okay.
2021.
Thank you. Can you tell us a bit more about this letter that was posted?
Yeah, so it basically states that there will be a city inspector coming to view my unit. They'll be looking for compliance with zoning and development bylaw 3575, and that I should be available December 23rd, 2021 at 9 to meet him.
From that notification, could you tell what it was that the city wanted to inspect?
No, I wasn't 100% sure. I assumed it had to do with the audit, but I did not know.
So, was this inspection eventually conducted?
Yes, so a couple days before the inspection, I phoned and talked to Inspector Vincent to see if kind of what he was looking for, mainly because I mentioned I don't want to break any of the rules. So I just want to make sure I don't before he comes. And then he came on the 23rd and met me then.
Which month was this?
December 23rd, 2021.
And what happened during this inspection?
So he came in and he looked for the things he told me on the phone, which were a fire extinguisher, a fire escape plan, and also to make sure none of the bedrooms had locking doors. He then asked me if he could look through my fridge and my cupboards and my closet, which I didn't see a problem with. I had nothing to hide, and I let him do so.
So, just backing up a bit, Mr. Prinsky, you said during the phone call that the inspector has said he wanted to check things like the fire extinguisher in the building, the fire plan. Is that right?
Yes, correct.
Okay. Did he provide any other reason for the inspection?
No, he said that was about it, just those three things.
Okay. And so when the inspector started to look through your fridge and your closet, did you find any of that unusual?
I did find it unusual, but I thought I'm open book, so he can look and see what he has to say.
Okay. And did the inspector say anything to you afterwards?
He asked me for reasoning why the fridge was empty and why the cupboards were empty, which I explained to him. So the fridge is empty because I do eat out all the time. I'm not someone who cooks. And there's condiments and stuff in the fridge that I use for my takeout. Also, with regarding the clothes and stuff in the personal belongings, there's two reasons. One, I've had things stolen, which was said earlier that I guess that's my risk, but to evade that risk, I take them with me. And also, the other reason is the apartment is very small. There's not enough room for all of my belongings and guest belongings.
And did the inspector have anything to say in response to that?
He basically said he'll let the people back at the city know who will be making the decision, and then I'll hear from them then.
And what did you understand him to mean by that decision?
I took it to mean that it's not his call. He just reports what he sees.
So after this inspection in December of 2021, did you hear back from the city?
I did. I was given a sorry. I was given a email on January 12th letting me know that I was invited to an audit meeting.
And is there anything else that was in that email?
They let me know like the format of the meeting and asked if I would be able to attend, which I did confirm. And then they let me know the format of the meeting.
And did the city provide a reason for why they wanted this audit meeting?
No, they just I assumed it was to ask more questions, but they didn't say no.
Did you eventually attend this meeting?
I did, yes.
Okay. When was that?
January 20th, 2022.
Can you describe for us what happened?
So I had a phone call meeting with Miss Claire Thompson and STR clerk Nathaniel Chow. They let me know that there was 4 areas of concern for them, which were said before, but just to recap, there was the high frequency of bookings, the results of the inspection, the Airbnb ad line that I had on there, which says I live in the suburbs, and also the complaints from residents in the building.
So when Ms. Thompson and Mr. Chow told those issues to you, what happened after?
So I answer. Well, they asked me questions about each one. I answered them, and honestly, and I was very surprised to hear about the complaints. I did not know that was coming. Anyway, so we talked about what I said, and then they let me know what they thought.
And what did they say they thought?
They said that they would not be recommending to keep my short-term license based on the facts that they said at the beginning, even though I had tried to explain to them the reasons why I felt that I was still complying with the bylaw.
So after you gave your reasons, they told you right after that they're not supporting your application?
Yes, correct.
I'd like to go over each of those 4 areas. So first off is the number of bookings. What was your response to Ms. Thompson and Mr. Chow regarding that?
I said that because of the pandemic, I was working from home. Like other people in the city, they had to be stuck in an apartment building. My partner's home in Langley is larger, so I spent more time there to take advantage of the space, also to mitigate the stress of living alone. I also said that I spent my time at my partner's house, but the high number of bookings is reflective of my lifestyle change that I had to make because of the pandemic and not what I had intended or what I permanently want to do.
And let me ask you, Mr. Frinsky, related to this, what you were saying about your partner's house.
Yeah.
Don't you also own that property in Langley?
I do, yes.
So why do you characterize it as your partner's house?
So we own both properties together. We've done that because for estate issues. Basically, we're not married, but if something happens to one of us, we want to make sure that it's very easy for the other one to deal with the repercussions of someone dying or being incapacitated where they can't own a property.
Do you have any more questions?
Oh, yes, I do.
And can you share with me how many more questions you have, or you're not sure?
Um, there will likely be around 15 minutes more.
15 minutes more. Okay. Thank you.
Okay,
Go ahead.
and regarding the second area that the city raised with you, the lack of personal belongings in the unit, did you explain to Ms. Thompson and Mr. Shao?
Yes, I explained. I gave the exact same reasons I gave to Inspector Vincent when he came. That was, again, because I was worried about theft, as it's happened to me before. And they've taken many different things, toilet paper. So, I mean, obviously, I have to take some risk on some of those items, but I didn't want to lose anything high value. So that's why I took it with me. Regarding the fridge, I eat out. So that's basically why there was no food.
What did Ms. Thompson say? Did she have any response to that?
She said she understood what I said. She didn't say whether she believed me or not.
Okay. And what about the third area of complaint or third issue, the statement on the Airbnb page?
So the statement on the Airbnb page, I understand how it sounds. It was not intended for that reason. So basically, we had a couple people come and stay who expected me to be there at a moment's notice. I think they assumed that I still live in the building and could just pop over and help them with something. I don't, because when I am not there, I do stay at my partner's house in Langley. So I am available by phone, but I need to make them understand that I am not specifically there 2 minutes away to come at their beck and call. So that was the intent of that.
And okay, and so we've covered. Okay, moving on. And after this conference with the city, do you feel you had a fair chance to explain your side of the story to them?
No, I don't really. I felt that whatever I had to say, not that was not taken into consideration, but I felt that they'd already made up their minds. I'd chosen to rent out my unit not to make money per se, but because Vancouver is so expensive to live in, I needed the income when I was not staying there and to be able to sustain it. I live downtown because I enjoy the lifestyle. Everything's so close, so it's easy to be active. And no matter where else I've lived, this city fits my lifestyle the best. I felt like I've done my due diligence, looking for and complying with all the bylaws. And when I spoke to Ms. Thompson, I let her know, like, I'm not a person who tries to break rules purposefully. Anything I did would be unintentional. And that it was the first year of me renting the unit. So there was a major learning curve for me. And I asked Ms. Thompson if our meeting could be a learning opportunity. I feel like just canceling my license is unfair. I feel like I should be given a second chance. I feel like I've answered all the questions and explained all the concerns that Ms. Thompson had. And I feel like I haven't given a reason for anyone to not believe what I'm saying.
And do you feel you had a fair chance to discuss with the city your side of the story that you're telling us?
No, I really only had one opportunity.
And what was
which
that?
was the audit meeting.
Mr. Frinsky, what is your understanding of what constitutes a principal place of residence?
So my understanding is really based on the bylaw that the city has given, which is that it's a place where you live, where you make your home, where you conduct your daily affairs. And I feel like I comply with all of those things.
And did you make the Richard Street property your home and conduct your daily affairs there?
Yes, all of my bills come there. All of my identification is there. I use Like I said before, I use the gym, I use the pool, I live in the unit.
Do you know if, according to the city's bylaw or any other guidance the city you may have seen, if you are required to live in the Richard Street property a certain number of days per year in order to meet this principal residence definition?
No, that's not part of their bylaw, as it was stated earlier, and also what I'm looking at now. I've also made sure I was right. So my partner, on my behalf, called the city to specifically ask them, and the clerk that he talked to said, correct, there is no minimum number of days. I do have the transcript of that if anyone needs that.
Do you believe you're in compliance with the city's principal residence requirement?
Yes.
Mr. Frinsky, aside from everything we've covered, is there anything you would like to say to the members of the council today?
I would respectfully like to ask that you've kept an open mind when you've been listening to me. And also, I would respectfully ask for a second chance. I understand that according to the compliance or the short-term rental group, that they don't feel I live in the unit, but I would like a second chance to prove that, as I don't feel like I have been given a fair shot to do so.
Thank you. No further questions.
Thanks. Panel members, do you have any questions for Mr. Frinsky? I have one. So, Mr. Frinsky,
Yes.
I'm wondering if you can tell me if you file your income tax return to the address on Richard Street
I do,
that you
yes.
claim as your home. So, under the Canadian government's income tax, like on their website, it clearly says that the housing unit representing the taxpayer's principal residence generally must be inhabited by the taxpayer or by his or her spouse or common law partner, former spouse or common law partner or child, and a taxpayer can only designate one property as his or her principal residence for a particular tax year. So, in considering that, can you tell me how many actual nights you slept in um, the property in question
For
for the
what
past
time
year?
frame from last year,
Last
2021?
year, yeah.
I would say it's about 50 days or so.
So 50 days out of the 365.
Correct.
Okay. Thank you. That's my only question. I don't know why I'm coming up as Mayor Stewart, but I'm sure Tita, you'll make sure that that's corrected in the minutes for whatever reasons. I don't see anyone else on the panel. Robert, do you have any questions for Mr. Frinsky?
I do, Mr. Frensky. I'm going to ask that you turn to page 24 of the evidence materials. And you were asked by your counselor, how many days were booked in August 2020. Your answer was approximately 2.5 weeks to 3 weeks. I've reviewed the calendar, and I count that in fact 25 days out of 31 days were booked in October 2020. Would you agree with the 25 days?
Yes.
Okay. So when you guessed 2.5 to 3 weeks, that was a guess. You weren't trying to minimize
Correct.
the amount of days.
Correct.
Okay. And with respect to the 50 days that you just indicated to the panel that you slept at the Richard Street address, that too was a guess. You're not trying to minimize that. That's just your off the top of your head guess.
Correct.
You wouldn't dispute with the numbers calculated by Mr. Miyagi, though, that over the period from October 2020 to October 2021, there was a vacancy of 37 days at which you could have stayed at the unit.
I'd have to double check, but when I counted, it was 52, I think. So I would have to double check that.
Between October 2021 to between October 2020 to October 2021.
Yes.
Okay. All right. You're satisfied to say that it was somewhere between Mr. Miyagi's calculation and your calculation.
Yes, correct.
Thank you. I'm going to ask now that you turn to the page before that. What we're looking at here is an ICBC. This is page 23 of the evidence material. What we have here is a document from ICBC indicating your prior registered addresses with them.
Yep.
And there was some reference to this in Mr. Miyagi's evidence. This was a document that you submitted in the course of the audit request by the city. Is that right?
That's correct.
And what seems to be disclosed today is that prior to your acquisition of the 928 Richard Street property, you were residing at 4759 202 Street in Langley.
Yes,
Correct?
that's correct.
Okay. And you started residing there in and around August 2017?
No, November 2018.
It says effective date October. Okay, so the term date it said effective date August 2017, or sorry, August 2017, and then term date.
That's the address before that.
Okay, so you started residing at. Sorry, I'm looking at the wrong one. 4759 202 Street, Langley.
Yes.
Effective date November 29th, 2018, correct?
Yes, correct.
That's in and around the time that you purchased the property with your partner.
Yes.
And you lived at that address and considered it your principal residence up until around the end of July 2020.
That's correct.
And July 2020 is when you then took possession of the unit at 928 Richard Street.
August 1st, but yes, around there, yes.
Around there.
Yeah.
So essentially, we have a situation where you lived with your partner full time for a little under 2 years, and then made a decision in July 2020 that you were going to have a principal residence elsewhere.
Yes, correct.
Okay. Now, you indicated that you did not live as much in the 928 Richard Street property because you had to adjust because of COVID. Is that fair to say?
That's fair, yes.
But you purchased this about 4 months into COVID. Fair to say?
Yes.
COVID was already going on. You knew what you were getting into.
Correct.
Okay. Notwithstanding that, you found that you didn't want to reside in the small space.
Correct.
It
was not as easy as I thought it would be.
Okay. And so you then, over the course of, say, starting in October 2020 to around October 2021, you would periodically stay at 928 Richard Street, correct?
Correct.
The indication from Mr. Miyagi was that that period couldn't have been no more than 8 days in a row. You agree with that?
I agree, yes.
Okay. And the total would be that you would have spent at 928 Richard Street was approximately 10%, while you spent about 90% of your time back in Langley at the residence that you had lived at for 2 years full time.
That's correct.
Now, you answered the letter that's at page 13. Letter at page 13, you referred to. This was a request for the audit notification letter. And there are several numbers or letters at the bottom of that page, A, B, C, D, E. E directly asks you for a operational summary, and that operational summary at point I includes the requirement to disclose the locations you stay when guests are present in your home. Locations being possibly multiple or possibly singular, correct?
Correct.
At page 16, you provide your response to that, and you indicate towards the bottom of your email at point E, while the unit is in use, I stay at my partner's house. Correct?
Yes.
Okay. And you use partner's house, so that's the only place you would stay if your condo downtown was being rented?
Yes, or maybe holidays. I didn't write that at the time, or I could have gone away on vacation.
Okay. I'm going to The word misleading was used in questions to Mr. Miyagi. I'm going to suggest another phrase, and I'm going to say this is somewhat of a half truth. Is that fair to say?
I wouldn't say so, no.
Um, I stay at my partner's house. Whose house is it, Mr. Frinsky?
Well, technically, we both own the house. However, it's not my primary residence, but it is his primary residence. So that's why I've said that.
You're of the view that even though you spend in and around 90% of your time at a house that you co-own, that does not constitute your primary residence under the interpretation of that definition under the city's bylaw.
Correct, because there is no minimum number in the bylaw.
Okay. And I'm going to suggest again that this is a half-truth. It is your partner's house, but it also is your house, correct?
I would say, again, I own the house, yes, but it is not my primary residence.
Why didn't you just rent it out to a long-term renter, Mr. Frinsky?
Because I do want to use it.
You want to use it in stretches of 8 days, 5 days, 3 days, every now and then?
Again, it's COVID prevented me from trying to enjoy it as much as I wanted to. So I did rent it more often than I wanted to.
Okay, and that's why I'm asking. If you're not going to live there 90% of the time, why wouldn't you just rent it out full time to somebody?
So the plan was to use it way more and then rent it out when I am not using it.
Thank you. Those are my questions.
Thanks. Now, Council, we're on to closing submissions by the City of Vancouver's Council. Robert, please go ahead.
Thank you. We've heard from Mr. Frinsky. You've heard from Mr. Miyagi. I don't want this panel to get sidetracked on a couple of issues, and I'll tell you what those issues are. The first issue is this is not about motivated complaints from complainants who have an axe to grind with Mr. Frinsky. What's clearly revealed by the evidence is that 3 complaints were received, all of which alluded to the fact that Mr. Frinsky didn't live there. What the city does with those complaints is investigate them, and they look for things that either negate those claims or that corroborate those claims. The things that corroborate those claims are the things that were uncovered in the course of the investigation. The fact that Mr. Frinsky spends over 90% of his time in a residence that he owns in Langley is a consideration. The fact that he claims to live in a sanitized apartment free of any personal effects is a consideration. The fact that he advertises on his Airbnb that we live in the suburbs is a consideration. So don't get sidetracked by the inner workings and politics of strata councils. This is about whether or not Mr. Frinsky has satisfied the permanent residency requirement, principal residency requirement. To that end, I'm going to ask that you reflect on the cross-examination of Mr. Miyagi. It was pointed, it was aggressive. It was a cross-examination that we would expect to see in a criminal trial where the Crown or the government needs to prove something to the standard of beyond a reasonable doubt. It was intended to plant a seed in your mind that the city hasn't proved that Mr. Frinsky doesn't live there. That's not what you have to consider. This is stemming from an audit process wherein Mr. Frinsky was unable to satisfy the chief license inspector that he met the residency requirement. The evidence to that end has been put before you. What the chief license inspector did is what this panel has to do. You need to interpret the principal residence definition under the bylaw with consideration of the policy objective. The policy objective of the short-term rental licensing scheme is to preserve long-term housing stock. It is not to permit people to rent their place out on a short-term basis for 90% of a period between October 2020 and October 2021. Mr. Frinsky could have either left his unit vacant or he could have rented it on a long-term basis. But as it is, this panel is being asked to find that a residence that he claims to have lived in as a principal residence for at most 8 days in a row and less than 90% of the time over a span of more than a year means the usual dwelling unit where he lives, makes home, and conducts their daily affairs. And I think it's fair enough to ask yourselves, if Mr. Frinsky was going to have a dinner party, where was he going to have that? At the place that he lived at more than 90% of the time and owned in Langley? Or the place that he's trying to rent out over 90% of the time on a short-term basis in downtown Vancouver? So the question at the end of the day is, has Mr. Frinsky satisfied this panel that this is a principal residence unit under the definition of the bylaw? And respectfully, deference is owed to the chief license inspector on that point. These are not the types of units that are intended to be allowed for short-term rental because they do not preserve permanent housing stock. Those are my submissions. Thank you.
Thank you. And now it's time for closing submissions from the applicant or the applicant's counsel.
Yes, thank you. Mr. and Madam Councilors, you've heard from the applicant, Mr. Frinsky, today about his living circumstances. You've heard from him his reasons why he lived at the unit for far less time in those years. And the takeaway I'd ask you to consider is that the city is applying a rigid standard, a rigid assessment right now of how they view Mr. Frinsky's alleged non-compliance with the bylaw. The city is using these numbers, like 91% of the time, that he was only there 8 days in a row. And these are all true. Mr. Frinsky has candidly and has been candid and forthright about all this. But the fact is that, speaking of these policy objectives, Mr. Frinsky's intention, as you've heard from him today, he has testified, always was to use this place as his principal residence. Of course, there was he bought the house, the property, after COVID happened, but then he couldn't have foreseen that it didn't work out for him and it just wasn't good for him. And so he started to rent out the unit more, but he still thought he was in compliance. Perhaps he was mistaken. We submit that he was not, but that was always his intention. And so what I ask for you, Mr. and Madam Councilors, is that you take this into consideration. The city has taken, like I said, a very rigid approach in terms of how they want to view this. It's a 90% that he hasn't been there a certain amount of days. And if that was the case, I would submit to you that perhaps the laws should be that clear and that rigid, that it shouldn't be that ambiguous statement in the city's bylaw that Mr. Miyagi earlier testified that it was deliberately left ambiguous. Perhaps then, if the city wants to apply a rigid definition and judgment onto every holder of these short-term rental licenses, then the bylaw should be that clear. Then there would be no reason for anyone to come up and argue those points because it is clear as day. But I submit to you, it is not. Mr. Frinsky thought he was in compliance with the bylaw. And he thought, based on his circumstances, even though he was going to use it a lot more, he thought even then, even though he rented it out more, that he was still in compliance. When Mr. Frinsky was told the first time of this, he, as you heard from him, he contacted the city at several points trying to get clarification on this. His partner, Danuka, also contacted the city saying, oh, is there a certain amount of days we are supposed to live, that Mr. Frinsky is supposed to live there? And the city said, no, there's not a certain amount of days you're supposed to live there. It was never clear to Mr. Frinsky from the start and even throughout this audit process what exactly he had to do. And he wants to be in compliance. I would address briefly Mr. LeBlanc's earlier statement about how this is not about motivated complaints and retaliation. And I respectfully disagree with that because that is an area that the city has based its reason for refusing to support Mr. Frinsky's application. The city states in its own letter, and I will quote here, that the city has determined that in consideration of the totality of information, including the information provided at the meeting, the inspection of your property, your high frequency of bookings, and information from community members, it does not support the 2502928 Richards Street. It was a consideration for the chief license inspector, and respectfully, the chief license inspector made it erroneously. He based part of his decision on complaints from residents in the building that were motivated by, quite frankly, nefarious means. They, as Mr. Frinsky testified, they directly told him, this is retaliation for you. And we submit that that is, as you now have heard today, it's an erroneous basis for their decision. And we also submit that the other bases for the chief license inspector's decision are also flawed. The lack of personal belongings in the unit. Mr. Frinsky has explained that. He just doesn't keep things there around because he's had items stolen. He keeps it. And Mr. Frinsky didn't testify earlier as to his cleanliness, but I would submit it's similar. It's just his lifestyle. He keeps it very nice and clean. In terms of also his fridge, he just eats out a lot. That's also just the way he lives his life. And as for that single statement on that Airbnb page that Mr. Frinsky said that we live in the suburbs, he has provided his explanation for that, and we submit that is not a reasonable basis on which the city license inspector should have decided that it would not support Mr. Frinsky's application. And all of this ties into the last point, which is the high frequency of bookings in the unit. And it goes back to what I earlier said about the bylaw, that it was simply not clear to Mr. Frinsky. He thought that he was still in compliance, even though he was renting out the unit a lot more than he had originally intended. And as Mr. Frinsky has testified earlier today, if he was told at any time, he would have wanted to comply with the rules. He would have done whatever was necessary so that he was in compliance. And so, if today, Mr. and Madam Councilors, you decide that Mr. Frinsky was still not in strict compliance with the definition of the bylaw, we ask that you give him another chance. You've heard from today, you've seen, I hope, how sincere he was. This is what he's asking for, that you give him another chance to try to conduct his short-term rental. If at any time in the future, things are brought up, then what can he say? But right now, you've heard how forthright he was, how honest he was about how he was in compliance. And so we ask that, please, give him a chance. Give him a chance to do, if the city gives more clear guidelines that they want him at the property 50% of the time, 60% of the time, 70% of the time, then I submit that perhaps someone should tell that to Mr. Frinsky instead of the city telling his partner Danuka that there is no such requirement. If this was made clear to him, Mr. Frinsky today, I submit to you, is ready to comply with whatever the city requires. He truly wants to maintain this short-term rental license in order to support his mortgage for this unit when he's not using it. It's a big help for him for his mortgage payments. And so we ask that the city give him a second chance. Thank you.
Thank you. Now it's time for discussion from the panel. I'm wondering if, oh, I see Councillor Carr on. Councillor Carr, do you have any discussion or a motion perhaps? Please go ahead. Clerk, if you could turn on Councillor Carr's microphone. Thank you.
Great, thank you. Yes, I have submitted a motion to the clerk. I'm not so sure if the clerk wants to bring it up, but
I think
I'll,
we have to bring it up there, Councillor Carr, if you'll just wait a moment and
well,
once it's on the screen.
sure.
But go ahead. Go ahead.
As
Just want to make sure
as it's
everyone
coming
can
up,
see it.
sorry,
Yeah.
pardon me.
Go ahead. Go ahead.
Yeah, I'll read it as it comes up on the screen. That the business license hearing panel uphold the city's chief license inspector's decision to not support the issuance of a 2022 business license to Russell Frinsky, the applicant, for a short-term rental accommodation at 2502-928 Richard Street, Vancouver, BC, the premises, on the basis that he does not comply with the short-term rental bylaw regulations and requirements of the license bylaw number 4450, in that the premises are not his principal residence. And, you know, the first thing I want to say is that I appreciate
Just
the,
before you go forward, I just have to see, Councillor Carr, sorry to interrupt you. Do we have a seconder for this motion?
Second.
Okay, Councillor Swanson seconds. Please go ahead, Councillor Carr.
great, thank you. You know, first of all, I appreciate the honesty of Mr. Frinsky. And he was very open and honest with us about, you know, the situation in his life, about the amount of time he spent or did not spend at the premises, the reasons for it, for which I'm actually sympathetic. I think COVID has thrown a lot of our lives into disarray. And it has been very difficult for many people to live in smaller units. I do really understand that. But you know, I have to deal with a decision based on what the bylaws actually state and the regulations that surround the short-term rental in the city. So I'm going to go back to a point raised by council here, which is that the reason we brought in the short-term rental regulations was because of an increasing number of empty homes in the city, which were being rented out on a short-term basis. In a situation in Vancouver where we are indeed in a housing crisis and there are not enough units available to rent on a long-term basis, it was a measure we chose to pursue, and it has made a big difference in terms of the city and the availability. The number of rental units available have gone up, especially in parts of the downtown area, most notably in Cole Harbour and Yaletown. And, you know, and the reason for that, as I say, is simply because of the crisis that we're in. I think it's very clear that notwithstanding that there isn't a number of days attached to it, I think the notion of principal residence is very clear, which is the place where you spend the your primary amount of time sleeping, living, conducting your life. And that hasn't been the case. And there's been honesty about that. The issue is not whether or not there are days in the bylaw. The issue is really understanding, and I think there is an understanding of what a principal residence is. In terms of, so all of the issues of the number of days, I'll just point to that. There was clarity and there was honesty, and I appreciate that. The situation is that we could have asked for a longer sort of suspension, but a 1 year perhaps gives time to rethink. Maybe COVID will be different. It's changing out there right now, but we're not sure. But anyway, at this point, I do believe that the motion I've proposed is in line with the requirements that are stated in our bylaw and in the policy, and the policy is there for a reason.
Okay, I don't see anyone else on the queue, so I'm going to call the question, and I'm just going to do it verbally. But if I hear that it's not unanimous, we will go to recorded vote. All in favor, please
Aye.
say aye.
Aye.
Any opposed? None opposed. The motion carries. And if I could get a motion to adjourn.
So move.
Second.
Second, thanks. Counselor Swanson seconds. All in favor?
Aye.
Yay.
Thank you very much. This motion carries and the hearing's adjourned. Thank you, clerks. Thank you, staff. Thank you, council. Bye.
Yeah, thanks, everyone.